My father was explaining to the probate court mediator why my name did not appear on the deed to the house my grandmother had promised me, when the bank trust officer walked in and set a file on the table. My father stopped talking. The trust officer said, "I apologize for the delay. I have the original trust document and the 1994 property provision. The primary beneficiary for the real property is listed on page 4. The mediator opened the file. She turned to page 4. She read it. Then she looked at my father. He rubbed the side of his jaw with 2 fingers. He did not look at me, the mediator said. "Mr. Cho, this provision appears to predate the deed transfer by 22 years. Can you explain why this trust was not disclosed in the estate filing?" My father said, "I was not aware the trust was still active. My father had been managing my grandmother's finances for 11 years before she died. I had the bank statements to prove it. My name is Miriam Cho. I am 44 years old, and I work in estate accounting and forensic financial examination in Raleigh, North Carolina. I have spent 17 years untangling other people's family money problems. I have sat across from clients who could not understand how assets they believed were theirs had ended up somewhere else, and I have walked them through the paper trail that answered the question. I did not expect to become my own client. My grandmother, Eleanor Cho, raised me from the time I was 8 years old. My parents decided when my brother Raymond was born that the house was too small and too loud and too complicated with 2 children. I was the older one. I was the one who could be moved. My grandmother had a house with a spare room and time to fill it, and so I was taken to her house in a suburb of Durham and left there with my clothes and my backpack and the understanding that this was how things were going to be for a while. My grandmother lived on Prescott Street in a house with a covered front porch and a backyard that had one old oak tree she had been trying to manage since 1972. The spare bedroom had a twin bed with a green comforter and a window that faced the side yard. I slept in that room for 10 years. I did my homework at the kitchen table. I learned to cook a few things badly in that kitchen. I watched television with her on Friday nights. She was a quiet person, not cold, just economical with words. She said what she meant and did not repeat herself. For a while lasted 10 years. I went home for summers and some holidays. I was not mistreated at home. I want to be clear about that. My parents were not cruel to me when I was there, they were simply more focused on Raymond, who was younger and louder and more present in the daily rhythm of their household. I had become something they thought about at the edges. My grandmother was not a wealthy woman. She had a 3-bedroom house in Durham that she owned outright, a modest savings account, a social security check that came on the 3rd of every month, and a specific quiet devotion to me that I had not fully understood until I was an adult. She fed me. She helped me with homework. She drove me to school every morning until I was old enough to take the bus, and then she watched from the porch until the bus came. She told me, when I was 16, that she had made arrangements. She said the house would come to me. She said she had taken care of it years ago with a document at the bank. She did not use legal language. She was not a legal language person. She just said she had put my name on the house at the bank, and that when she was gone it would be mine. I believed her. I did not ask for the document. I trusted her. I was 16 and she was the most reliable person in my life, and the idea that she would say something that was not true had never occurred to me and did not occur to me. Then I went on with my life. I finished high school at my grandmother's house, then college, then a graduate program in accounting, then the work I do now. I built everything I have from the ground up, without help from my parents in any financial sense. They had Raymond to help, and I had the combination of my grandmother's consistent presence and my own stubbornness. I do not say that with bitterness. I say it because it is relevant to what I understood the house to mean. My grandmother had given me something more valuable than the house during those 10 years, but she had also given me the house, and she had done it in writing, at a bank, with my name on the document. She had made it real in the way that real things need to be made real, so that no one could unmake it later, except that someone had. She died 2 years ago, at 89, in the house she had raised me in. She was clear-minded in her final weeks. The decline had plateaued in the last year, and she knew who we were and where she was and what she wanted. She died on a Tuesday morning with Raymond beside her, because he lived 40 minutes away, and I was 2 hours out in Raleigh, and did not make it in time. I have not made peace with that. I do not think I need to. Some things simply happened the way they happened. 3 months after her death, my father told me the house had been transferred to Raymond. He called on a Sunday afternoon, the way he always calls with difficult news. On a weekend, when he has had time to prepare, when he believes you will be less likely to respond sharply, said, "I wanted to let you know we handled the house. Raymond is going to keep it in the family. He is planning to renovate it." I said, "Handled it how?" He said, "The deed was transferred. Raymond is on the title now." I said, "When?" He said, "A few months before your grandmother passed. She wanted it settled while she was still alive to see it." I said, "She told me that house was mine." He said, "Your grandmother always wanted what was best for the whole family. Raymond has a family. He has children. The house makes sense for him." I said, "Dad, she told me directly when I was 16. He said, 'Miriam, you live in Raleigh. You have a life there. You never needed that house.'" That was the sentence. Not a denial, not a refutation. Free. Just the logic that had organized my entire family life from the time I was 8 years old. Raymond needed things, and I did not need them, and that made everything that followed reasonable. If you have ever been told you do not need something that was always supposed to be yours, you know what that sentence does to you. It is not a slap. It is a quiet revision. It tells you that your life, your stability, your competence, your ability to handle things, these are reasons to receive less, not reasons to receive what you were promised. The better you are at managing on your own, the more you can be managed out of what belongs to you. I did not argue with him on that call. I said okay. I told him I needed to think. I hung up. Then I drove to Durham. My grandmother had kept her important papers in a filing cabinet in the second bedroom, the room I had slept in for 10 years. The cabinet was still there when I arrived. My father had removed some documents for the estate filing, but the cabinet had not been cleared. I went through it systematically, the way I go through every file, front to back, reading every label, not skipping anything because it looked routine. I went through the filing cabinet from front to back, the way I had been trained, reading every label, not skipping anything that looked routine, because routine is where things get hidden. The front 2 drawers held tax records going back 20 years, insurance policies, medical files for my grandmother and my late grandfather, documentation for the house, the mortgage discharge from 1988, the property survey, the homeowner's insurance renewal every year in its own folder. In the 3rd drawer, behind a set of folders for utility records and appliance manuals, there was a pale blue bank envelope. The kind that is printed with a bank's return address in the upper left corner and sealed with a flap that has dried out over decades. The envelope was addressed to me. My name, my grandmother's address. No stamp, it had never been mailed. It had been in that drawer for 30 years. Inside was a single folded document, a letter from a trust department at a regional bank in Durham, dated 1994. The letter confirmed the establishment of a revocable living trust in the name of Eleanor May Cho, and identified the trust's assets and beneficiary provisions. The letter referenced a specific real property provision covering the family home at my grandmother's address, with the primary beneficiary listed as Miriam Jean Chomi, age 14 in 1994, named as the primary beneficiary of the real property. The letter also referenced the full trust document on file at the bank and noted that a copy had been provided to the truster for her records. I sat on the floor of the second bedroom and read that letter 4 times. My grandmother had established the trust in 1994. She had written my name into it as the person who would receive the house. She had kept a confirmation letter in the same drawer for 30 years. She had never mailed it to me, never told me the details, never asked me to do anything with it. She had simply preserved it, quietly and without ceremony, in the place where she kept the things that mattered. She had trusted that one day it would be needed. I put the letter back in the envelope. I drove home to Raleigh. The next morning I called the bank. The bank trust department took 4 days to respond to my inquiry. The representative I spoke with was careful. She confirmed the trust existed, confirmed it was on file, and told me she could not release the full document without the estate attorney's authorization or a formal legal request. I told her I was the named beneficiary. She said she needed the authorization regardless. I called Catherine Park that same afternoon. The trust was still on file. Revocable trusts can be amended by the trustor during their lifetime, but this one had not been amended since 1997, when my grandmother had updated the savings account provisions after my grandfather died. The real property provision from 1994 had not been changed. The trust was active. My name was still in it. And the house had been deeded to Raymond 6 months before my grandmother died. That combination should not have been possible. If the property was a trust asset at the time of the deed transfer, the truster or trustee would have needed to formally remove it from the trust before it could be conveyed by deed. The deed alone, signed outside the trust framework, would have been defective. A title company doing a proper search should have caught it. I requested the title search records from the closing. The title search had been conducted by a one-person operation in Durham that I had never heard of. The report was 2 pages. It did not reference the trust at all. A proper title search queries the grantor-grantee index and would have surfaced the 1994 trust instrument. This one had not. I added that to the file. The question was how those two things could both be true. If the trust held the property, the deed transfer should have required the trust's cooperation. A trustee would have needed to sign off on the transfer, or the property would have needed to be removed from the trust before it could be deeded out. Either action would have produced a paper trail. I requested the full trust file from the bank. It arrived 10 days later, 43 pages, and I read it at my kitchen table over the course of one evening. The trust had originally included the house as a trust asset. The 1994 document was clear on this. But in 2018, 4 years before my grandmother died, a trust amendment had been filed. The amendment removed the real property from the trust and reclassified it as a personal asset held outside the trust structure. The amendment had been signed by my grandmother, or rather, it bore her signature. The notarization was from a mobile notary service in Durham. The notary's name was on the stamp. I wrote down the notary's name. I also wrote down the date of the amendment. March 2018. My grandmother had been 85 years old. She had been diagnosed with early-stage cognitive decline 8 months earlier. My father had managed my grandmother's finances from 2011 until her death. He had her power of attorney. He paid her bills, managed her bank accounts, handled her correspondence, and drove her to medical appointments twice a week in her final years. He had been a devoted son by every measure I could observe. He had sat beside her hospital bed during each admission. He had learned her medication schedule and administered it correctly. He had not exploited her financially in the crude ways I see in elder abuse cases, skimming her Social Security, draining her savings account, changing her beneficiary designations on her life insurance. He had done something more precise. He had used his access and her trust to address one specific asset in one specific way, at a moment when her ability to push back was reduced. I did not accuse him of anything yet. I had done this work long enough to know that what I had was a question, not an answer. The question was whether my grandmother, at 85 with documented cognitive decline, had understood what she was signing when she removed the house from the trust. And underneath that question was a harder one. Whether my father had known she did not fully understand, and had let the signing proceed anyway. I pulled my grandmother's bank statements from 2011 to her death, which Catherine A. obtained through the estate proceeding. I was not looking for embezzlement. I was looking for context, the pattern of how my father had used his access over 11 years, which would tell me something about whether the 2018 amendment was an anomaly or a pattern. The statement showed 11 years of legitimate, careful management. Bills paid on time, medical expenses properly handled, no unusual transfers to personal accounts, no skimming. He had been a good steward, except for one thing. In the 6 months before the trust amendment was signed, there were 4 payments to the mobile notary service. Not 4. 3 were for routine documents, a medical authorization, a banking power of attorney update, and a home repair contract. The 4th, in March 2018, corresponded to the trust amendment date. He had been using the mobile notary regularly. He knew the service, he knew the process. The trust amendment was not the first time he had arranged a signing at his mother's home. It was simply the one that mattered most to the outcome. For me, I retained an attorney named Catherine Park, who handled probate disputes and elder financial abuse cases in Durham. She had a straightforward manner and did not charge for the first consultation. When I laid out the timeline, she said, "The cognitive decline documentation is important. If she lacked capacity at the time of the amendment may be voidable. And if the amendment is voided, the original trust terms apply. which means the property transfer to your brother is also problematic. I said, the deed transfer happened in September 2021, 6 months before she died. Catherine said, by then, her diagnosis had progressed. Do you have medical records from that period? I said, I'm requesting them. She said, get them. And get the mobile notary's records. If the notary was hired without your grandmother understanding what she was signing, that matters. My grandmother's physician released her cognitive assessment records after Catherine submitted the formal request through the estate dispute proceeding. The records covered 2017 through her death. My grandmother had been evaluated every 6 months from the time of her diagnosis. The evaluations used a standard cognitive assessment battery, the kind that measures orientation, short-term memory, ability to follow multi-step instructions, and capacity for abstract reasoning. Her scores had declined steadily from 2017 forward, tracking the normal progression of her condition. In March 2018, when the trust amendment was signed, her most recent evaluation, conducted 2 months prior, had rated her at a level the physician described in the chart as moderate impairment. The notes included specific observations: difficulty retaining new information across a session, inconsistent recall of recent events, and elevated susceptibility to following the lead of familiar individuals when presented with unfamiliar tasks. The physician had added a recommendation to the chart. All significant financial decisions should be reviewed by a neutral third party or patient advocate before execution. No neutral third party had reviewed the trust amendment. No patient advocate had been involved. No one outside my father had been consulted. The mobile notary's records, obtained through Catherine's subpoena, showed that the service had been contacted by Leonard Cho. He had called, described the document, and scheduled the appointment for a Tuesday afternoon. The notary's log noted one witness present during the signing, L. Cho. He had arranged for a notary to come to his mother's home, with a document that removed the house from a 24-year trust provision bearing his daughter's name. While his mother was in a state that her own physician had flagged as requiring oversight, and he had been the only other person in the room. Catherine filed the estate dispute and the petition to void the trust amendment in the same week. The argument was direct. The amendment had been executed during a period of documented cognitive impairment, arranged by a family member, with full access and a direct financial interest in the outcome, without independent oversight, and in a manner inconsistent with the physician's own recommendations. The deed transfer to Raymond had been possible only because of the amendment. Void the amendment, void the deed. Raymond called me 3 days after he received the filing notice. Raymond is 3 years older than me, in ways that matter more than the calendar. He has always been the one my parents worried about in the productive sense, the one who needed opportunities, who needed support, who needed someone to smooth the path. He is not a bad person. He is a person who has never once had to consider that something he received might have belonged to someone else. He called on a Tuesday evening. He said, Miriam, I don't know what you think is happening here, but I had nothing to do with however Grandma arranged her estate. I said, I know you didn't arrange it. I'm not filing against you personally. I'm filing against the amendment that made the deed transfer possible. He said, I already started the renovation. I pulled permits, I signed contracts. I said, I know. He said, this is going to cost me money I've already spent. I said, the house was supposed to come to me. Grandma put my name in a trust in 1994. I have the document. He was quiet for a moment. He said, she changed her mind. I said, she changed her mind at 85 with documented cognitive decline. While Dad was in the room and the notary was hired by Dad. Another silence. He said, you think Dad did something wrong? I said, I think the records tell a story that needs to be examined. He said, she was his mother. He was taking care of her. I said, I know that too. He said, you're going to tear this family apart. I said, Raymond. She kept a letter with my name on it in her drawer for 30 years. She put my name in that trust when I was 14. She never changed that provision in 24 years. And then, 4 years before she died, when she was 85 and struggling with her memory, a document appeared that removed the house from the trust. That's not a change of heart. That's a gap in the record that needs an explanation. He did not respond to that. He said he would talk to his attorney. My father called me the next morning. My father's voice when he called, had the particular quality of someone who has made peace with a position before the conversation begins. He was not defensive, he was explanatory. He had been explanatory my entire life. He said, "Your grandmother wanted Raymond to have that house. She said it many times in her last years." I said, "Did she say it before or after her cognitive decline diagnosis?" A pause. He said, "She was still herself, Miriam. She was still clear about what she wanted." I said, Her physician documented moderate impairment in March 2018. That's when the trust amendment was signed." He said, "She understood what she was signing." I said, "Physicians said she had increased susceptibility to suggestion from trusted individuals and difficulty processing new legal and financial information." Those are the physician's exact words. "You were her most trusted individual. You arranged the notary. You were in the room," he said. "I was helping her execute her wishes." I said, "I have the 1994 trust document. I have her signature on a beneficiary provision naming me specifically. Free. I have 24 years of no changes to that provision. And I have a 2018 amendment that appeared while she was cognitively impaired, arranged by you, that removed the property from the trust so it could be deeded to Raymond." He said, "She loved Raymond. She loved his children." I said, "She loved me too, Dad. She raised me." He was quiet. I said, "She kept a letter in her kitchen drawer for 30 years with my name on it. She put that letter away and she kept it. That letter is the reason I know what she intended." He said, "I did what she asked me to do." I said, "Then explain it to the court." The hearing was scheduled in the Durham County Probate Court. It was not a full trial. Green. Catherine had filed for a summary determination on the trust amendment's validity, and the court had scheduled a mediation session first to see whether the parties could reach a resolution without extended litigation. My father arrived with an attorney I had not met before. Raymond arrived separately, also with counsel. My mother came with my father, but sat in the hallway during the mediation itself. When I walked past her, she looked at me with an expression that I could not fully read, not anger, not sympathy, something is more complicated. She put her hand briefly on my arm and said nothing. The mediation room was small. A rectangular table, 6 chairs, a window that looked onto a parking structure. I arrived early and sat facing the door so I could see everyone come in. My father came in without looking at me. He sat 2 chairs away from his attorney and arranged his hands on the table. He was wearing the same kind of dress shirt he always wore to anything official, light blue, pressed, the collar open by one button. He looked like a man who had decided the way to handle this was to be visibly reasonable, because being visibly reasonable had gotten him through most situations. Raymond came in separately 3 minutes later. He looked tired. He sat at the far end of the table and did not look at me either. Front. He had a folder in front of him that I assumed contained the renovation permits and contractor agreements. The folder sat unopened on the table throughout the mediation. The mediator was a woman named Sandra Osei, a retired judge who had been doing this work for 8 years. She reviewed the filing before we sat down, and she was prepared. She had read the trust document, the amendment, the physician's records, and the notary records before she entered the room. I could tell because she went directly to the relevant pages without searching. She opened with the trust document. She said, "Mrs. Cho, your grandmother, established this trust in 1994 and named you as the primary beneficiary of the real property provision. That provision remained unchanged for 24 years. In 2018, an amendment removed the property from the trust. In 2021, the property was deeded to your brother. The petition argues the 2018 amendment was executed during a period of documented cognitive impairment. Is that the central claim?" I said yes, and that the amendment was arranged by my father, who had power of attorney and was present during the signing. My father's attorney said, "Mrs. Cho executed the amendment voluntarily. Her signature was notarized." Sandra Osei said, "Notarization verifies identity and willingness to sign. It does not verify legal capacity. The physician's records are before me, and they are clear about her cognitive status at the time." My father's attorney said, "Cognitive decline does not automatically void a legal document. Many individuals with mild impairment retain legal capacity." Sandra Osei said, "The physician used the word moderate, and the physician specifically noted increased susceptibility to suggestion from trusted individuals." Mr. Cho arranged the notary, was present during the signing, and had full control over his mother's financial affairs. She looked at my father directly. "Mr. Cho, What was your mother's understanding of what she was signing in March 2018? My father said she knew she was changing the house arrangements. Sandra Osei said, praying. Did she know the change would remove her granddaughter as the beneficiary under a trust she had maintained for 24 years? A long pause. My father said, she knew the house was going to Raymond. Sandra Osei wrote something on her pad. She said, let's take a recess. They were out for 35 minutes. When the bank trust officer arrived midway through the recess with the complete file, the recess extended another 20 minutes. When everyone came back, my father's attorney said, my client is prepared to discuss a resolution. The resolution took 2 hours. I want to tell you what those 2 hours felt like, because I think people imagine these mediations as dramatic, raised voices, tears, someone storming out. This one was not like that. It was quiet and procedural and exhausting in the specific ways of rooms where everyone is being very careful with their words while something large gets decided. The trust amendment was stipulated as voidable by consent, which meant my father did not have to admit to anything formally, but also meant the amendment had no legal effect. With the amendment voided, the original 1994 trust terms controlled the property. Raymond's deed transfer was declared invalid under the court's determination that the property had been a trust asset at the time of the transfer, and the transfer had not followed the trust's required procedures. The deed was voided. 4. The property was placed under the administration of a third-party trustee, pending final distribution under the original trust terms. The trustee would oversee the transfer of the property to me as the named beneficiary. Raymond's renovation permits were suspended while the property changed hands. The contractor he had hired had been paid a partial deposit, $14,000. I later learned through Raymond's attorney's correspondence. That dispute was between Raymond and the contractor, and the court had no jurisdiction over it. Raymond sat at the end of the table. While the settlement terms were read, he did not object, he did not argue. He opened the folder he had brought and looked at his permits, and then he closed the folder, and he set it down, and he sat with his hands flat on the table for the rest of the session. When the mediator finished reading the terms and asked if both parties confirmed understanding, Raymond said yes. His voice was even. He did not look at me. I do not know what he was feeling. I know what the renovation had cost him up to that point. I know he had already ordered materials. I know he had told his children they were going to have a place to spend holidays. I know none of that was his fault in the way my father's actions were his fault. Raymond had received what he was given and had started building on it in good faith. That is the part of these situations that does not resolve cleanly. Someone loses something they thought was theirs because it was given to them improperly, and the improper giving was not their idea. Raymond paid for what my father arranged. That is not justice, it is just how it fell. My father did not speak to me directly during or after the mediation. He and my mother left together without looking back. My mother paused in the doorway of the mediation room for a moment. She looked at me. She started to say something and then did not. She followed my father out. Catherine walked with me to the elevator. She said, "That went better than I expected." I said, "The trust officer arriving with the complete file helped." Catherine said, "Your grandmother set that file up in 1994. It was sitting in a bank trust department for 28 years. All we had to do was ask for it." The property transferred to me 6 weeks after the hearing. The trustee Catherine had nominated was a local estate administrator named Paul Everett, who had managed dozens of similar transfers in Durham County. He was efficient and uninterested in the family dimensions of the case, which was exactly what I needed. He processed the transfer in the standard timeline, issued the updated deed, and sent me the final paperwork by certified mail. I did not move into the house. I drove to Durham the week after the transfer completed, and I walked through every room. Raymond had already begun the renovation before the permits were suspended. The kitchen had been partially gutted. The lower cabinets were gone, the countertops removed, the floor in that section covered with plywood. The appliances had been moved to the dining room and covered with drop cloths. The window over the sink was the same one my grandmother had looked out every morning for 40 years. The wall beside it still had a small nail hole where she had hung a calendar every January. I stood in the kitchen for a long time. The third drawer, where the envelope had been, was still there. The drawer hardware was still the same. I opened it out of habit, the way you open a drawer you opened 1,000 times as a child, knowing it would be empty. It was empty, but I knew what had been in it. 3. The second bedroom, where I had slept for 10 years, still had the same painted window trim. The kitchen still had the same drawer hardware. The kitchen was where my grandmother had kept the pale blue envelope in the third drawer. Behind the utility folders for 30 years, I stood in that kitchen for a while. She had never mailed the letter. She had written my name on the envelope, put the trust confirmation inside, sealed it, and kept it in a kitchen drawer for 30 years, without saying a word to me about it. I think she believed the trust would handle itself. I think she believed the bank had the document, and the document would speak for itself when the time came. She was right. It did. It just needed someone to go looking. Have you ever been the person in your family who everyone called responsible, capable, independent, the one who needed less, the one who could handle things, the one they moved to a smaller room because you would be fine? If that is you, I want to ask you something. When is the last time you checked the documents? The will, the trust, the deed, the beneficiary form, the estate filing? Not because you are suspicious, but because the documents are the record of what people actually decided. And sometimes the record and the conversation do not match. My grandmother told me the house was mine when I was 16. She backed it up in 1994 with a trust document. Nobody needed to take my word for it. The bank had the file. Raymond and I have not spoken since the hearing. I am not certain that is permanent. I think Raymond is working something out about the house, about what he understood versus what was actually true, about whether there is a version of this that lets him believe his father acted in good faith. I do not know what conclusion he will reach. I have stopped waiting for the phone to ring. My father and I speak occasionally, brief, careful exchanges about my mother's health, about logistics. The conversations are shorter than they used to be. There is a layer of something underneath them that we have both decided for now not to address directly. He has not apologized. I have not demanded one. We are operating in the specific quiet that follows a confrontation where both parties know what happened, and neither is ready to name it out loud. My mother called me once, about a month after the hearing. She said she was glad I was going to have the house. She said Grandma would have been glad too. She started to say something else. I could hear her choosing the words, then setting them aside. And then she just asked how I was sleeping. I said fine. She said good. We talked for 20 minutes about nothing in particular, and then said goodbye. She loves my father. She loves me. Flute. She knows more than she has said and less than I know, and probably more than she wants to know. And she is doing the thing that women in families often do, which is hold the shape of a thing together by not pressing on it too hard. I understand that. I do not agree with it, but I understand it. I had the kitchen restored instead of renovated. Raymond's contractor had removed the lower cabinets and the countertops, and the cost to put them back the way they were turned out to be less than finishing the modern renovation would have cost. I found countertop material that matched the original color closely enough. I rehung the same cabinet hardware. The third drawer is back. I kept the same drawer. The house is rented now to a young family who uses the second bedroom as a nursery. They have a toddler who, the mother told me when they moved in, likes to look out the window at the side yard in the morning. I check on it twice a year. I sit in the driveway for a few minutes when I arrive. I think about my grandmother and the kitchen and the 30 years she kept a letter with my name on it in a drawer where she kept the utility bills, the way you keep something in a place where it will not get lost. She could have mailed it. She could have told me. She could have walked me through the trust documents and made sure I understood every provision. She did not do any of those things. She simply trusted that the record she had created would outlast anyone's attempt to undo it. It was almost right. Almost. If you have ever been the one in your family who was told you did not need things that others needed, and you stayed quiet because you believed the people who said it, subscribe. Rumi. These stories are for people who finally stop taking that on faith and start reading the documents. My father said the house was never mine. He just forgot my grandmother spent 30 years keeping a letter in a kitchen drawer that said otherwise. Cool. The pale blue envelope is in my desk at work, in the top left drawer, where I keep things I need to be able to reach without thinking. It is faded at the corners and the seal dried out decades ago. My grandmother's handwriting on the front is still clear. My name, her address. No stamp. She kept it for me. She just never mailed it, and the bank kept the rest. If you believe the truth always shows up somewhere in the records, subscribe before the next account is opened. She mailed that letter to me 30 years ago and never said a word. She just trusted that one day I would open it.